안녕하십니까. 2021년 케일로 포럼에 참석해 주신 웨빈 여러분 모두 반갑습니다. 오늘 진행을 맡게 된 한국법제연구원 최지연입니다. 한국법제연구원이 주최하는 이번 포럼은 국내외 한국법 전문가들, 한국, 미국, 유럽 지역에서 활동하시는 여러분들을 모시고 해외 한국법 연구와 교육의 현황과 쟁점을 주제로 심도 있게 논의하는 장이라고 할 수 있겠습니다. 어제 진행되었던 1세션에 이어서 오늘은 미국 동부, 미국 서부의 한국법 전문가분들 그리고 한국의 한국법 연구자분들과 함께 발제 토론을 진행하도록 하겠습니다. 지금 시작하는 2세션은 오전 10시까지 그리고 10시 30분부터 3세션이 시작될 예정이니 많은 관심과 참여 부탁드립니다. 안내 말씀 잠깐 드리고 시작하도록 하겠습니다. 오늘 행사는 서울에서 이렇게 오프라인으로 진행이 되고 있고 온라인으로 발제자 토론자분들을 모시고 있는데요. 코로나19 확산 방지를 위해서 사회적 거리두기 방침에 따라 방역 수칙을 지키고 현장에서는 최소한의 인원으로 함께 행사를 진행하고 있습니다. 그리고 지금 포럼에 온라인으로 참여해 주시는 분들이 많은데 이번 포럼에 참여해 주신 온라인 참여자분들께는 포럼 참석 증명서를 발급해 드리고 있습니다. 시청하고 계시는 송출 화면을 캡처해서 이벤트 페이지에 업로드해 주시면 행사 후 참여 신청서를 보내드릴 예정입니다. 참여는 현재 유튜브를 통해서 보여지는 화면 내 QR코드로 하시거나 아니면 유튜브 송출 화면 하단의 더보기에 있는 링크를 참고해 주시면 되겠습니다. 그럼 오늘 세션 2를 시작을 하면서 한국법제연구원 김계영 원장님께 개회사를 부탁드리도록 하겠습니다. 김계영 원장님.
네, 여러분 안녕하십니까. 한국법제연구원의 원장 김계용입니다. 2012년 말 저희 연구원은 세계 한국법학자 대회를 개최하였습니다. 이후 매년 이렇게 해외에서 한국법을 연구하고 가르치시는 학자들을 모시고 현재 KLRI 포럼으로 거듭나오기까지 이제 10년의 세월이 되었습니다. 세계 속에서 한국법에 관심을 가지고 연구하신 여러분들의 열정과 노고를 기리며 KLRI 포럼 10주년을 성대하게 함께 축하하고 싶었지만 작년에 올해도 코로나로 이렇게 화상으로만 인사드리게 되어서 매우 아쉽습니다. 어제는 1세션으로 유럽에서 한국법과 과의 비교 연구를 진행해 주시는 두 분 교수님과 국내 학자를 모시고 제1세션을 진행했습니다. 오늘은 이제 그 이튿날이고요. 오늘 두 번째 세션에서는 미국 동부권 시간대에 계시는 세 분을 발제로 모시게 되었습니다. 먼저 플로리다 대학교의 로버트 준호 리 교수님께서 풀브라이트 스칼라로 미국법을 가르치고 한국법을 배우며 얻은 교훈에 대해서 경험을 나누어 주시고, 콜롬비아 대학교 노정호 교수님이 미국법과 한국법상 북한 주민의 인권 보호에 대해서 말씀해 주시겠습니다. 이어서 오하이오 대학교 링컨 데이비스 교수님이 국제법 연구 방법에 대해서 발표해 주시면, 여기 한국의 한동대학교에서 미국법을 가르치시고 계시는 원재천 교수님이 세 분의 발제에 대해서 토론을 진행해 주시게 됩니다. 오늘 세 분의 주제 발표와 토론은 이번 KLRI 포럼의 대주제인 해외 한국법 연구와 교육의 현황과 쟁점에 가장 잘 부합하는 내용이 되지 않을까 싶습니다. 온라인 회의는 현장에서 뵙고 함께 토론하는 것보다 더욱 집중이 필요한 것 같습니다. 게다가 미국 현지 시간은 저녁이고 한국은 이른 아침이라 우리 모두 더욱 힘써 발표를 경청하고 토론에 참여해야 될 것 같습니다. 여러분의 열띤 논의를 기대하겠습니다. 감사합니다.
네, 감사합니다, 원장님. 그럼 오늘 참여해 주시는 발제자 토론자분들을 소개해 드리도록 하겠습니다. 먼저 첫 번째로 발제를 맡아주실 플로리다 대학교 러빈 법과대학 법학 교수인 이준호 교수님이십니다. 로버트 주노 리 교수님께서는 상법과 회사법을 주로 가르치고 계시고요. 이전에 플로리다 대학교에 재직하시기 이전에는 연방 순회 항소법원의 연구관 그리고 법무부의 우수 소송 변호사로 일을 하셨고 또 MBA를 하셨어요. 그래서 투자은행 등 여러 금융기관에서 인수 합병 업무도 하신 것으로 알고 있습니다. 두 번째 발제자를 소개해 드리겠습니다. 두 번째 발제자는 컬럼비아 대학교 법학전문대학원의 한국법학 센터장이신 노정호 교수님이십니다. 컬럼비아 대학교로 자리를 옮기시기 이전에는 한국연세대에서 교수로 재직하셨고요. 당시에 한국 정부의 고문으로서 북한을 여러 차례 방문하시면서 한국의 통일 문제에 대해서 연구를 해 오셨습니다. 세 번째 발제를 맡아주실 분은 오하이오 주립대학교 모리츠 법과대학의 학장이신 링컨 데이비스 교수님이십니다. 에너지 환경법, 행정법을 전공하시고 교수 재직 이전에는 유타 대법원에서 연구관으로 근무하셨고 로펌에서도 근무를 하신 변호사이십니다. 한국에도 서울대나 경북대에서 연구를 하신 바 있고 시드니대에서도 연구 활동을 하신 적 있습니다. 그리고 세 분의 발제를 모두 함께 토론으로 이어주실 분은 한국의 한동대학교 법학부 교수이고 국제법센터장이면서 국제중재조정원 부원장을 맡고 계시는 원재천 교수님이십니다. 원재천 교수님은 국방부의 국제법 전문가로 활동을 하시고 이전에 뉴욕주 검사로 활동을 하시다가 2001년도에 한동대로 자리를 옮기셨습니다. 2013년도에는 한동대에서 평화화해연구소의 설립을 맡으시고 소장직을 맡고 계십니다. 이렇게 발제자와 토론자분들을 모시고 여기 현장에서는 저희 방금 개회사를 해주신 한국법제연구원 김계홍 원장님 같이 해주시고 계시고요. 그리고 여기 케일로 포럼을 담당하고 있는 사업 법제 교류 지원 사업의 책임을 맡고 계시는 김지훈 한국법제연구원 기획실장님 같이 해주시고 계십니다. 그리고 이번 행사를 준비해 주신 한국법제연구원 백영주 연구원님 같이 자리를 하고 계십니다. 그럼 지금부터 오래 기다리셨습니다. 발제를 진행하도록 하겠습니다. 첫 번째 발표는 플로리다 대학교 레빈 법과대학의 로버트 주노 리 법학 교수께서 풀브라이트 학자로서 미국법을 가르치고 한국법을 공부하면서 배운 교훈이라는 주제로 발표해 주시겠습니다.
Thank you. Good morning. 안녕하십니까. So my topic, keeping in mind the general thesis of this conference, which is current issues in Korean legal studies. My topic is one of the lessons that I personally learned in teaching U.S. law and studying Korean law as a scholar. So I very much also want to emphasize the fact that I was a teacher in Korea, but also very much a student there as well. So I want to talk about 3 points. Some of the experiences of teaching U.S. law to Korean and international students, studying Korean law, for the projects that I had proposed going into my full year in Korea, and some of the things that I personally have learned about Korean law. My experience was as a Fulbright scholar at Yonsei University. I spent an entire year in Korea. My own personal experiences, I have gone back to the country of my birth many times. So this is not the first time back, nor the first time, in fact, at Yonsei. I had been a student at Yonsei for the summer program, which Yonsei is quite famous for back in, I believe it was summer 1989. But this was the first sustained long-term period as a professional and as an adult in Korea. So my purpose was really to propose a teaching package and a research agenda for this Fulbright lectureship. In terms of teaching, this is the package. So this is actually the letter, my application letter. And this is the package of courses that I have proposed to the Fulbright committee. I have proposed that teaching U.S. corporation law. Of course, when we talk about U.S. corporation law, there is no single federal, general federal chartering system in the U.S. We're really talking about state law. There's 50 state laws, but Delaware is a leading jurisdiction for corporation law in the United States. Corporation, U.S. corporate law
Professor Lee,
proviso.
excuse
Yes?
me. I'm sorry, Professor Lee. Can you please share your screen and the slides? We are not seeing any of your slides.
Yes,
yet.
thank you. I
sorry.
appreciate that. Yeah.
And also, we are running
There we are.
against the clock to make this as compact as possible. So I forgot to
Sounds
mention that,
good.
but would you be able to finish your presentation in 20 minutes from now on? Thank you.
Oh, more than that. Yeah, definitely. I'll be able to do that in 20 minutes. So can everybody see the screen now? Yes, good. The course package that I proposed was corporation law, unincorporated business enterprises, which are really partnerships and limited liability companies. And maybe in the Q&A session, we can talk about that a little bit more, particularly partnerships and LLCs, which are very prominent here in the US, but I did not think that I saw that kind of a prominence in Korea. And maybe we can touch on that a little bit later in the Q&A. Corporate finance, which is mainly focused on financial contracting, although there's a substantial amount of corporation law there as well, and securities regulation. So in the United States, if one law school student wanted to study business law, this could be a package that forms the foundation of studying business law. And this is what I proposed in teaching experience, I had a mix of international students there. Of course, Korean students, American students, and I had a mix of students from various countries. So it was quite an enriching, rewarding experience. The first problem I encountered was how to actually deliver the lessons. And this is actually more significant than what it first sounds like. So one of the things that I don't think that I could have done really was to just say, here are some books, buy the books and let's talk about them. There's the logistical problem of buying books, but in addition to that, I think one has to be really sensitive to the fact that there's some materials that might not be really relevant to Korean or international students, and also sensitive to the fact that we might not be able to have the same type of coverage in light of not only the different styles and different pedagogical methods, but also keeping in mind that there could be a slight language issue as well. I didn't find actually the language issue to be much of a problem at all. The students that I came across were actually quite fluent. I think the spoken English was somewhat more variable, but certainly in terms of reading, and there were more than up to speed on English, and it's a real credit to the general educational system that we have in certain countries, Korea being a prime example. So bottom line, I think the students learned the material quite well. Again, one has to be somewhat sensitive to the fact that certain coverage of materials is really not needed for Korean students or international students. I'll give you one that comes from corporation law, which is the internal affairs doctrine, which is the doctrine of choice of law. And we have 50 corporation laws. Which one do you choose? Which law applies? I think that's probably a rule that, while important in the U.S., it's one that can be kind of glossed over, perhaps in other settings. So I want to move on to the research agenda. So I had some inquiries, and going into the experience, And it is really one of general comparative study. What are the Korean rules? How can we compare Korean rules to American rules? And are there things that we can learn from each? And that was basically the proposal. The final products, I think, have changed in the course of a year, and then post the sabbatical, the Fulbright experience, and then coming back to the U.S. and then really thinking about what I learned for an entire year. So in terms of the final product, what happened was there were two things that I produced that came directly out of the Fulbright experience. One was going back to the teaching experience, which was that, well, how do I put together a series of teaching materials for students that would be appropriate? So at least with respect to partnerships and limited liability companies, these organizations that we call non-corporate business entities, I had to actually produce the materials myself, and ultimately the production of these materials for the purposes of teaching in Korea became a book. And it's a book that I published called LLCs, Partnerships and Corporations, and it's the picture that you see here of the cover of the book on the left. The more academic piece of the scholarly agenda was an article that I had written, and it's called The Political Economy of Corporate Law and Governance, American and Korean Rules Under Different Endogenous Conditions and Forms of Capitalism. So with respect to the academic article, there's been, of course, much discussion and much criticism of the chaebol system. That's not new. That has been going on for at least several decades. And I think there's a large consensus on some of the problematic aspects of the chaebol system. And in fact, some of my colleagues in Korea have noted or observed that Korea is the only country that actually has a system like this, in that a small minority shareholder can exert this type of control over entire corporate groups. That would be an outlier. I suppose in the United States, I can think of the Ford Motor Company where that is the case, where a small minority shareholder, the Ford family, exerts control over the company as a result of dual class stocks that they own. But it's really an outlier here. So I wanted to study this, but at the same time, I came to the realization, well, if I have write something, a critique of this, it would simply be the 40th article. I'm exaggerating, but you understand the point. It would be just another Me Too type an article, and I didn't want to do that. So instead, the query changed into, well, there are flaws in any given system. There might be pros and cons to any given system. So people have focused on the cons, on the flaws. So in terms of a pros and cons, a cost-benefit type of analysis, why is it that the country does this, holds this kind of a system? So that was the main focus of this article. And essentially I have come to the conclusion that that the systems of capitalism in the US and Korea are very much distant, that the corporate systems in the United States and Korea are very much different, and that the conceptions of the corporation and its function in society are different. And it is these differences that really result in what on first pass, maybe second pass or third pass, looks like a very peculiar system, maybe peculiar to an outsider coming in. So ultimately, I think the conclusions or some of the lessons learned is that to do a comparative study, you really have to, I think for me, it was very helpful to have a broader understanding of the history, the culture, and the economic organization of a particular society. And if we can have some deeper learning on those fronts, then maybe we can have a better understanding of what otherwise have been called by many scholars, including Korean scholars, scholars inside Korea, scholars outside of Korea, Korean scholars outside of Korea, and also American scholars as well, as a peculiar system. So those are some of the main takeaways that I've learned. So those are the two things: that teaching Korean law, teaching American law in Korea, as well as just trying to learn Korean law myself and trying to understand certain aspects of Korean law myself. Just a brief comment, it was a tremendous professional and personal experience. Here's a picture on the left is a picture of Korean judges. All of those judges that you see there have an affiliation with the University of Florida. They have spent their sabbatical years at the University of Florida, and it was a great get together in Korea that we had. Of course, when I was there, I had a chance to go to the Olympics as well, so that was a great experience. So with that, I will conclude this talk, and thank you very much.
감사합니다, 교수님. 풀브라이트 스칼러로 연세대에서 가르치시고 이제 학생들을 만나고 연구를 하셨던 그 경험을 나눠주셨는데요. 저희가 어제 세션에서도 그런 이야기들이 있었어요. 유럽에서 한국법을 공부하시는 분들이 한국법 교재로 사용할 만한 그 자료가 별로 없어서 어려움을 겪는다라는 말씀을 해주셨는데, 오늘도 교수님께서는 한국에서 미국법 강의를 하는 데 있어서 미국 교재는 분명히 있지만 그래도 이것들을 한국에 있는 학생들에게 사용하는 데 있어서 어느 정도의 법 적용의 문제라든지 뭐 교재의 분량이라든지 여러 가지 면에서 또 그대로 가져와서 쓰기에는 어려움이 또 있었다라는 말씀을 해주셔서 이렇게 여러 가지 다양한 시각이 있을 수 있고 생각지 못했던 어려움들이 여러 가지 상황에서는 있을 수 있구나 하는 걸 알 수 있게 되었습니다. 그리고 강의하시고 연구하시면서 한국의 회사법 재벌 문제를 연구하셨던 경험을 나눠주셨는데요. 아무래도 그 사회에 대해서 이렇게 그 폭넓은 이해를 바탕으로 법학 연구를 더욱 깊이 할 수 있었던 것으로 생각됩니다. 원재천 교수님께서 이제 교수님의 발제에 대해서 토론을 준비해 주시는 동안 제가 두 번째 발제 로정호 교수님의 미국 및 한국법에 따른 북한 인권 보호에 대한 발제를 듣도록 하겠습니다. 로정호 교수님 부탁드립니다.
I'd like to thank KLRI and President Kim for continuing to hold the series under very difficult circumstances. And I think every year that I've participated in this forum, I've always come away with a kind of a very nuanced and new viewpoint about the study and the teaching of Korean law and Korean system in the United States. For this year's topic, I chose North Korea, and in particular, I chose human rights as a kind of a stepping stone into kind of understanding, what is the at stake in the Korean studies. And here, the problem with human rights is that the concept of human rights really does not exist in the abstract. It is always traditionally kind of weighed against the multitudes of other considerations, and particularly, for instance, national security, or in the North Korean case, denuclearization. But more fundamentally, at the very heart of modern kind of civilized society is this concept of protection of human rights, and that has to be central, I think, to a democratic society. And as a nation, it forms a very important part of the psyche of understanding a particular country and really defining who we are. And here, I think North Korea presents a really very interesting and new type of inquiry into this. Okay. For this, I chose not just to focus on North Korean human rights, but really to focus on how we approach North Korea and its human rights. And here, I named this the post-Trump human rights policy. The reason why is that prior to Biden, Trump had a very different view of human rights, and especially North Korea, than its predecessors and also Biden. So here, one of the, I think, most important points that I think we have to understand is that fostering democracy and protecting human rights is one of the most important new pillars under US foreign policy in general, not just on North Korea. But then this is not new. And here I think it's an important point to make is that the concept of protecting human rights in North Korea has been embedded in US law since 2004. So it's really been there, but there's been very different variations of the way the human rights has been approached in the United States. So just as an example, the new kind of policy is on other countries is going as far as to say that the atrocities committed by the Armenians centuries ago by the Ottoman Empire, defining this now as genocide after the fact, many years later. That is, I think, an important kind of step in the right direction of recognizing that the violation of human rights is not a timely, just on the spot issue, but one that precedes history and is an important part of the way we define civilization. In addition, for instance, in Xinjiang, Hong Kong, the G7 countries, explicitly agree to call out human rights abuses. And another kind of development is some U.S. allies, including China, France, and Turkey, they are now going back to 2017 and now redefining the Myanmar as genocide. So now, specifically then, we addressing North Korean human rights, really, it goes down to kind of, I think, three different concepts here. Number one is, what is the international community? Number two, what is Seoul's role, South Korea's role in holding DPRK accountable for its human rights violations? And how about the United States? As you all know very well, the entire kind of UN-based North Korean human rights approach has been the Commission on Inquiry, which was the flagship study that was done by the United Nations calling out North Korea for its human rights violations. And this has really formed the, I think, core basis upon which other countries, including the United States, really have proceeded in addressing the human rights question in North Korea. I asked a question, what is Seoul's role? And I'll be discussing that in a little bit, and what measures have been taken by the United States. That will come in the next point. So South Korea, North Korean human rights is a matter of politics for South Korea, more so than any other country. Mainly due to the proximity of South Korea to North Korea, and obviously the fact that we were at one point one people, we have the same Korea, and hence, if you look at the South Korean law generally, it's incredibly robust. There are lots of laws dealing with it, and the laws that I've mentioned here are the ones that actually deal solely with human rights. The other laws that they have is, for instance, dealing with humanitarian aid, inter-Korea relations, inter-Korea cooperation. It's incredibly robust, but you will note that, in fact, when it comes to the actual human rights protection in South Korea, dealing with North Korea, it is very limited. And in a way, it's very general. And I'll get into that a little bit later. And I just mentioned, and I think Professor Won also is very intimately involved in a lot of this. But essentially, the South Korean law is based on the 2016 North Korean Human Rights Act. And underneath that is the National Human Rights Commission of Korea, Center for North Korean Human Rights Records, and North Korean Human Rights Documentation Office. Then obviously a very controversial law that was just passed, which is the Anti-Leaflet Law, which I will also be getting into in a little bit. How about the United States? The legal regime for the United States. Here, one would immediately kind of see that there is a disconnect between the United States and South Korea when it comes to North Korea human rights. we say from Trump, the America First kind of doctrine, under which there was Singapore, Hanoi, and Panmunjom, and some developments there, which did not really yield any kind of results. But then it goes to Biden, and here it's the calibrated and practical approach that is the hallmark of this administration. In Korean, 잘 조율되고 실용적인 접근. But in all of this, really, the United States falls under a law called the North Korean Human Rights Act of 2004, which has really been in existence since that time and has now really been the most important starting point of how the United States wants to address North Korean human rights protection. Just a quick overview. As originally passed in 2004, it gets reauthorized every 5 years or so. And the most recent reauthorization was in 2017. And this law is valid until the year 2022. Okay. Even though some of the goals of the Act include providing humanitarian aid, much like the South Korean law, most important part is really promoting democracy and human rights. And here is what really now, I think, sets the United States law apart from the South Korean law, is this notion of democracy and protection of human rights as an important foundation for human rights. And also another kind of interesting aspect is that North Korean citizens are eligible for political asylum in the United States. There are some conditions attached to whether, for instance, a person who comes to South Korea can apply for political asylum in the United States, but nonetheless, the route for political asylum in the United States is available. Okay, so I'm not going to go through all of the key provisions, but really kind of highlight a part of the American law dealing with North Korean human rights that contrasts and is kind of in conflict with the way South Korea has approached human rights. And again, the legislation is this. First of all, funding. Here, I think it's a very important part of where the United States and Korea kind of differ a little bit. Here in the United States, there's actually money that has been allocated for human rights protection. And in the most recent year, $24 million for humanitarian efforts, and $20 million for aid refugees. And the kind of interesting part is not the 20 million, but the last 2 millions that we have. 2 millions to promote human rights and democracy within North Korea, and $2 million a year to increase the free flow of information into North Korea, which has actually increased to 3 million. The reason why this is that this is essentially where I think the United States now attempts to approach protection of human rights through the prism of promoting democracy, promoting and giving free flow of information, as opposed to just criticizing or doing other kind of activities. And Korea, on the other hand, I think if you note here, oops, sorry, I'm not sure how to go back now. Okay, so since I don't know how to go back, I pressed this by mistake. I'll just catch up to this part. Korea, on the other hand, the provisions there are actually quite general, and there is no specific wording regarding how the protection of human rights will be actually manifested or carried out. The slide that I missed is a summary of the key provisions, and here is just essentially that the President of the United States is given the authority to fund non-governmental organizations, and here this is one of the most important part, and coming back to the key summary, which is this particular slide, is that it's to promote human rights, democracy, and open markets in North Korea through educational initiatives, and to increase the availability of information. And here, even though this sounds very vague, this really has been a part of the way the United States approaches human rights in other countries. And South Korea is also not an exception to this. In the past, before democracy came to South Korea, we also had an unfortunate history of kind of human rights kind of violations under the military dictatorship. And even then, at that time, really, in a way, the approach had been for information flows to promote democracy as the tools by which the United States addressed South Korean kind of human rights violations, among other things. So here, I think it's important to point out that that approach that the United States has really has not changed fundamentally when it comes to how the United States wants to kind of approach a gross violation of human rights. Of course, they include sanctions and other economic and other political means, but nonetheless, at its very core is this notion that promoting democracy is the way that the United States will address these issues. So, and essentially, how? And here, this is where now I think there's a slight kind of conflict with South Korean law. Here, specifically, the US law provides that distribution of information shall be done by means of radio USB drives, SD cards, audio, video players, cell phones, all kind of electronic materials. It's very specific that, in fact, these are the methods by which we want you to use to promote democracy and free flow of information. And the contents, include cultural materials, information regarding what rights North Korean people are entitled to under international law, and also religious content. So it's actually, in a way, very specifically targeted towards now kind of promoting this notion of democracy and freedom and rights. Now, of course, the key provisions in South Korea really is to promote inter-Korean human rights dialogue, but really nothing specific. Specific efforts to promote dialogue are prescribed in the presidential decree. Then humanitarian assistance, and also stipulates NGOs within Korea must ensure they follow certain guidelines regarding what kind of humanitarian aid. And here, in 2010, as all of you are probably very well aware, South Korea passed the Anti-Leaflet Law, which criminalized now sending propaganda leaflets into North Korea. And here, the problem really, of course, is that this is, in a way, in direct kind of conflict with the American kind of law, which now specifically provides for these kinds of direct means to promote democracy. And without going into kind of a discussion of the South Korean anti-leaflet law, I think it's kind of suffices to point out that in fact the reason why there is this kind of disconnect is because of the general disconnect that South Koreans and the US has towards the approach to human rights in North Korea. And in a way, this is a natural kind of result of that particular difference. Very quickly, I'm just I mentioned, one of the core elements of the U.S. Law was the kind of promotion of democracy and the free flow of information into North Korea. And in my kind of closing, what we need to, I think, be kind of aware of here is that the North Korean people are not aware of really what rights they have as a people. But in fact, they are entitled to certain inalienable kind of very basic human rights. And these rights are is something that North Koreans really don't have that much information about. And here, the United States, I think, is in the right path in a sense that to educate, to inform North Koreans about what really rights they have under international law is a very important part. For instance, here, the international treaties to which North Korea has acceded to are in the left-hand corner. The very basic civil and political rights, international covenants, economic and social, cultural rights, and number 3, importantly, elimination of all forms of discrimination against women, and then the Convention on the Rights of the Child, and Convention on the Rights of the Person. And so here, these are international obligations that North Korea has acceded to which the North Korean population needs to know that the government will be abiding by these particular set of international rules. And hence, what North Korea did, in fact, was enact, on the right-hand side, certain domestic legislation, Women's Rights Protection Act, Children's Rights Protection Act, Disabled Persons Protection Act, and Elderly Protection Law. So here, even though these laws do exist in the books, the fact of the matter is the general population of North Korea are not really aware that, in fact, these are the rights that they are entitled to. And if you read these laws, they're actually well-written laws, but under North Korean law and the actual system, they kind of are rather meaningless. And hence, that's where the gap, I think, exists there. The key takeaway really here is that because of this huge gap, even within North Korea, of the kind of knowledge or understanding of what rights the North Koreans are entitled to, I think the free flow of information, promotion of democracy, all of that really plays a tremendously important role. And I would really kind of hope that South Korea and the United States can actually coordinate a little bit more better regarding the kind of approach to North Korean human rights. So let me end there, and if I can unshare.
교수님, 작년에 저희가 케일로 포럼을 연말에 하면서 준비를 할 때에는 대선이 막 시작이 되고 있었던 때였고, 미국의 대선이, 그리고 케일로 포럼이 이제 개최가 되던 때에는 대선 결과가 나온 이후였거든요. 그때도 노정호 교수님께서 트럼프 어드미니스트레이션에서 바이든 어드미니스트레이션으로 넘어가면서 한국에 어떤 영향을 끼칠까, 이 부분에 대해서 또 심도 있는 논의를 이어주셨는데요. 오늘도 이제 바이든 정부 하에서 그러면은 북한 인권에 대해서 미국법이 가지는 그런 함의랄까요? 미국법의 의미 등을 한국의 이제 그 북한 주민과 인권에 대한 자세와 같이 비교해서 재원이라든지 자유로운 정보의 흐름 등을 들어서 설명을 잘 해주셨습니다. 여기에 대해서는 워낙에 또 우리 원재천 교수님께서 북한 인권 쪽으로 일가견이 있으셔서 또 심도 있는 논의를 준비를 해주실 것 같은데요. 일단 준비해 주실 동안 또 세 번째 발제자이신 오하이오 대학교 링컨 데이비스 교수님의 발제를 듣고 이제 세 분의 토론을 진행하도록 하겠습니다.
안녕하세요. Good morning, and from here, good evening. Great to see everyone. It's a pleasure to be with you and to get to see everyone. It's always an honor to be affiliated in any way with KLRI, and I'm very pleased to be able to get to speak with you all today. My only regret is that I don't get to do this somewhere in Korea, because it's always wonderful to be there. I'm going to be talking this evening or this morning for you all about conducting comparative international legal research. And my presentation is going to be fairly pragmatic and a little bit meta, in that I'm going to be talking a lot about sort of process and procedures, tips that I've learned and other scholars who conduct comparative research have learned over the years as I've talked with them. And so I'm hoping that by doing that, it will provide some insights and advice to people who might want to engage in this type of research. By definition, my research will be, or my presentation will be informed in part by my own experiences, but as I mentioned, I have talked with others who conduct this kind of comparative research for some ideas as well, and so want to thank them for the insights and advice they were able to share with me. I've organized my talk into sort of three parts. I want to talk about pitfalls, and I'm going to be using I thought about different ways of sort of giving ourselves mileposts as we walk through the presentation. I landed on video games in part because my son, who just finished high school, is back in the house now for a little bit, and I'm excited to have him around, and he's been playing a lot of video games. Of course, the ones I'm going to be showing are sort of more my vintage and less his. I could have used something else, military tactics, sports, games. I decided to go with video games. So I'm going to be talking first about pitfalls, then I'll be turning to tactics, and thirdly, I'll be talking about some strategy. So I want to talk about pitfalls first, just in terms of engaging in this research, because conducting comparative research can be quite time consuming, and it can be quite difficult, and it can lead down avenues that don't necessarily bear fruit. And so I think it's useful before you engage in the endeavor to think about what some of those pitfalls might be so you can try to avoid them. And I'll give you some tips next after the pitfalls in terms of ways that you might try to avoid them or at least circumvent the pitfalls. So the first pitfall that you might face if you're conducting some of this comparative research is just the failure to understand the broader context. And here I have an example of sort of, the US Supreme Court. Obviously, the court continues to change over time. But if you're not following the court carefully or understand what the different perspectives, different justices bring to the conversation, it may be hard to understand a particular decision by that court. For instance, Justice Thomas on the court is an originalist, and that perspective is a fairly unique one that not necessarily other courts or other justices share. And so reading a decision by him might, if you don't understand that, may lead to sort of a misunderstanding of the opinion. I was reading an opinion a week ago that came out earlier in this term, Virginia uranium case, in which Justice Gorsuch wrote an opinion for the court. It wasn't a majority opinion, in part because three justices who agreed clearly with all of his logic really disagreed with some extra statements he made about how you engage in statutory interpretation. I thought this is another example of really needing to understand the legal context, the social, cultural context, the political context. I faced this myself in one of the very first comparative projects I did. My very first time to Korea was in connection with KLRI. I was very pleased to speak at a conference there about renewable energy policy and law. And the country was shifting from a feed-in tariff regime to an RPS regime, a shift that other countries across the world have made as well. And I was able to sort of understand that context, but had somebody come in and just talked about the regimes sort of in a vacuum without understanding the transition that Korea was undergoing, their research might have suffered. So that's the first pitfall. The second pitfall I might mention is just access to primary source information. Here, because I like energy, I've used the example of the Federal Energy Regulatory Commission, the key regulating agency in the United States. But getting access to primary information and conducting comparative research has a few different obstacles that can come into play. One of them is just having uneven databases. Different countries keep their information different ways or might provide access to it in different ways. And if you're trying to conduct comparative research and you have one country that's really rich in the data and another one that it's harder to get access to, that can be a problem. Likewise, translation problems. If you think about conducting comparative research and different countries using different languages, Spain, for instance, might have some of its records in Spanish, but others in Catalan. And so getting translations of those may be more difficult the more sort of obscure a language or, the less folks who speak it might be. So that's another pitfall to keep in mind as you're designing your research project. A third is related. Here, of course, is the Trinity Library in Ireland. And the reason I mention this is simply that as well as having problems of unevenness in access to primary source information, you might also have unevenness in access to secondary source information. I've conducted research on solar support regimes, for instance, in the renewable energy policy context, and the literature in Europe is really rich in terms of how these regimes have been studied, how they've been discussed. The literature in the US is not as rich. And so if I want to use one of the examples of my own home jurisdiction that I understand the best, getting access to kind of that secondary research is a difficult task, simply because the literature just hasn't been developed as much. And you can, of course, run into this problem in a lot of different contexts. One other thing I'll mention here is what I call the novel question paradox, which is that the more novel the question is you're trying to address with your research, which of course is what we want to normally do when we're engaging in a research project, the more likely it is you're going to run into this problem when you're conducting comparative research of having unevenness of secondary sources. So that's the third pitfall I would mention, the lack of the risk of unevenness in secondary source information. The fourth is also related, which is just simply access to people. This is a general problem in our research. Sometimes if you're conducting legal research, it'd be wonderful to hear what judges are thinking behind the scenes, or what their strategy was when you're conducting research on legislation, what the drafters were really thinking behind the scenes. That's something that always is a problem, but when you start conducting comparative research, that can be exacerbated, both because of the unevenness of how much access you might have to that information from one jurisdiction to the next, but also because of the first problem we mentioned, the need to have kind of context when you're not somebody native to that country, and sort of understanding the broader fabric and environment in which that law is functioning. And so, part of what the problem here is, again, is just the notion of what this looks like and sort of being in and out of a network, and how you leverage a network. And I'll give some examples of maybe how to try to work around this later on in the presentation. One example of this that I faced was I was doing some research in Germany as part of a fellowship, interviewing people, and different parts of the country were sort of more willing to talk with me about the research than others. The government was quite open and willing to talk with me. Parts of NGOs or public interest groups were quite willing and open to talk to me, but getting industry to talk to me proved a lot more difficult. And so when I finished the project, I had uneven sort of information. I had lots of government information, lots of public interest information, and some industry information kind of concentrated around renewables, but getting the incumbent industry to talk to me proved a lot more difficult, and I had only a couple of interviews that I was able to conduct. And so this is another pitfall or problem, hurdle that can arise. The fifth I would just mention is the notion of sort of a project path dependency, or we might call this sort of a rabbit hole. There's a couple of different rabbit holes you might face when you're conducting comparative research. One is getting an idea early on of what the project it is you want to conduct, getting far down that path and finding out that the path isn't really bearing fruit in terms of the research productivity. A second one might be that it's harder to get a sense of what's really the sort of arterial versus the capillary when you aren't as familiar with an area or the jurisdiction. And so you might go down paths that are side paths that become tangents later on that really don't bear on the crux of what you determined the research to be. And so that's another risk you might face. The sixth and final pitfall I'll mention, of course, I had to throw in the home football stadium somehow here for Ohio State. But I think about this when I go to football games in Columbus, because there's a lot going on, right? The stadium's large, it's over 100,000 people. And there's this sort of question when you're conducting comparative research about the project versus an agenda. What is it you're engaging in that particular moment? And the same thing's happening on the field, right? With the players in a particular play or a series of plays as they're trying to move down the field, or with the band. We call our band the best damn band in the land. And what is it they're doing on the field? Are they forming something? Or are they just marching? And the same thing happens with your research. Are you in that moment engaged in a project that's a comparative project that's part of a broader agenda? For instance, one paper I wrote was about nuclear waste, and that particular paper wasn't comparative, but am I engaging in I'm going to have a broader agenda where I write a lot about nuclear waste and work toward a book and have a bunch of different papers examining this problem from different angles and trying to illuminate that? Or is or am I writing more about nuclear overall, and the waste problem is just sort of one piece, and I'll be moving on to an extra piece. I think that's a little bit easier to chart when you're thinking about it from a domestic perspective. When you start thinking about it from a comparative perspective, then you have to be, I think, more careful to think, okay, is this, is the comparative piece I'm doing here part of a larger agenda, or is my agenda a comparative agenda? Because that becomes a little bit more difficult. Okay, so those are some of the pitfalls that you might face as you conduct comparative legal research. Let me give you some tips then, or some tactics for how to maybe avoid them. I think my kids would have chosen a different video game to represent this, but I'm going to use Super Mario Brothers because that's the one that I grew up with, although here's the newer version that I have played with my son. And as you play these games, you figure out sort of moves you can make that improve your skill set. And I think the same can be true on the research front. So I'm going to give you 8 different tips, an auspicious number, and we'll just walk through each of those one at a time. So the first one is, I found that if you can find co-authors, particularly co-authors that have geographic diversity, or co-authors that have disciplinary diversity, that can really enrich and strengthen your work. So this photo is of me and one of my co-authors from Australia, Penny Crossley, who teaches at the University of Sydney Law School. We've done a couple of projects together, and we've used both examples from the US and Australia in our work. I wouldn't be able to get into an understanding of Australian law and policy in the kind of depth that she has mastered. And so by pairing my expertise in the US and her expertise in Australia, in that particular paper I'm thinking of, we actually had 2 other co-authors, one from Korea and one from England, where we had 4 different examples. We had a really sort of rich array of lessons we could talk about how the electricity sector was being regulated, because we brought each of these different perspectives to bear, and we didn't have to each master all 4 areas. We could put together from a parallel perspective what our insights were in each one, and then draw lessons from that juxtaposition. So a second tip is to utilize interviews when you can. I think interviews, whether they're a formal part of your research and you use them as part of your methodology, or an informal part where you help contextualize what it is you've learned from your review of the records or the law, can be really helpful. Another thing I'd mention about this is that if you can use the interviews to snowball, right? So you talk to one person and they mention 2 or 3 other people that you might want to talk to, and then you talk to them and they each mention a couple of people. If you have time to do that, that can really enrich your work, and from a comparative perspective, I think can also help become maybe part of the substantive methodology that really gives it some weight in terms of the lessons you might learn or bring to bear. Third tip is to aggressively pursue fact-checking in context. Obviously, this here is a bookstore in Seoul, but the point simply is that you're trying to get sort of grounding in what you're learning. Part of what you might want to do is just cast a wider net to try to read more and more about what different people are saying about the problem. And so, that might be newspapers, it might be media, it might be reports from the government or industry. Google is your friend here in terms of running different types of searches to find ways you can kind of cross-check informally the information you've learned. And the Wayback Machine is another really nice internet tool. If you find information that seems to be gone from the internet, but kind of what the URL might be to go back in time and look. That's something we've used regularly in our research. A fourth tip is to find informal reviewers. So here, this is a pretty informal picture. Obviously, this is several of my old colleagues at the University of Utah. We were at a Mexican restaurant. But the reason I like this photo for the point is that I think research is often really about people, and I think that's especially true from a comparative context. When you're conducting this type of research, there will be probably formal reviews conducted of your work, and that's good. That's good for the product and the quality of the product. But reaching out to others who have expertise in other areas or other countries can be a nice way to kind of get some check on your work, to leverage those networks, other scholars or other experts in the area, or even other attorneys who know it and can give you some guidance or feedback on, to make sure you haven't stepped too far off the right path. A fifth tip, and I've got the zombie meme here or emoji here because I think all of us to some degree when we've been on Zoom or FaceTime so much during the pandemic feel a little bit like zombies when we're on here. But the truth is, one of the silver linings of the COVID pandemic is, I think, helped flatten the world even more than it was already. And when we have the ability to talk with other people through technological means like Zoom, that really can be helpful in terms of conducting comparative research, especially maybe as you lay the groundwork to get context before you might visit a place and then conduct even more sort of in-depth in-person interviews. But just a note, time zones matter. A sixth tip, we've got 3 left here. A sixth tip is just to pick an area that has rich international data. You might have a series of different research projects that you're considering. And I think as you do that, some lead work will pay off to put in the time and energy to see, where is there international data that's rich that you can mine and look into, where is it going to be thinner. I've encountered this in some of my own projects where you look at, some of the information that's available for renewables from international agencies or international trade associations, and that might help shape which particular direction you might go into as you do your work. I wrote a piece for the KLRI Journal of Law and Legislation involving solar power, and that certainly came to bear as I worked on that piece, which examples I would use, which case studies I would use in there, based in part on what international data was available. And the case studies from the particular countries, that was informed by what was available there, but also the sort of overall shape of the project was informed by where there was international data available. And that was something I was able to ascertain before I defined the scope of the piece too finely. A seventh tip is just to leverage international travel, or to leverage your travel generally. I think whenever you're getting on a plane, thinking about ways to connect with others, other professors, other scholars, other experts in the area. I've certainly done this when I've gone to other countries. I mentioned being in Germany. I know I'm going to be, in Dresden. Okay, so I'm going to be talking to 2 people already. I'm going to go look and see if there are professors in the area who've written in other journals, who've written papers that are directly pertinent to my research agenda. I want to make sure I talk to them because, it's great to be there, but you don't want to waste the chance to talk with others while you're already there, given the cost and time of getting on a plane. And then 8th tip, and this is a photo from a conference I was at in Washington, D.C., where a bunch of scholars were talking about energy policy in the U.S. and electricity grid governance. Network. They say in the restaurant industry that location is what matters. It's location, location, location. I think when you're doing comparative research, networking is really the tagline. The more you can connect to people and have networks you can leverage over time, the better. So let me just end then by talking for a moment about strategy. I've talked about some tips, tactics, but obviously you want to put those tactics into a broader scale and think about an overall strategy as you go on. Here, this is, I think this is Metroid, the old game. I don't know when I played this, a long time ago, but it's less about maybe the tactics in the moment and the overall strategy you use. And so let me, of course, the other great old strategy game is Zelda. So let me just talk about 3 different key strategies you might want to have. And the first is just picking a topic for your research that can expand, shift, or shrink. Right? You might think it's about, your project is going to be about one thing and ends up being about another. I mentioned going to Germany and conducting this comparative project on US and Germany renewable energy policies. I thought my project was just about that, about the comparison. I ended up doing some of that comparative work later on, but as I was there, I realized there was this area about the particular tool that Germany had been using that was really underexplored. And I ended up writing that paper first. about feed-in tariffs and how those had kind of failed in a bunch of different countries. And I ended up using a comparative lens to do that. I talked about Germany, I talked about Korea, I talked about Spain, because they all had similar stories, although there were some differences among what happened in those countries. And so we were able to tease out tools about feed-in tariffs from the different experiences in those countries. I think if you don't have this kind of strategy in mind and you adhere to a kind of particular scope of your project, that can be a problem. So this is one strategy overall to use. A second strategy is to pick a topic where the examples are plentiful, because it may turn out that some of the examples you want to use don't work. I worked on a project once where I really wanted to use what was happening in India as the example, but it just turned out as I got deeper and deeper into that project, there wasn't a lot of information about what was happening in India, and I wasn't able to find the kind of network of people that could help me do that comparative work to have it robust enough that it would parallel the richness of the other examples I was using. So, pick a topic where you have lots of places to choose from if you're going to use case studies, but keep in mind, of course, the difference between causation and correlation, because that's something you always have to keep in mind, I think, when you're conducting comparative research. And then the third strategy I'll just point out is just to always be on the lookout, ready to pivot. This relates in part to the first in terms of how you choose your topic, but also just in terms of how you approach it. As you find additional information, as you find different leads, different questions that haven't been answered, be ready to maybe tackle those or to shift the scope of your project. And so with that, I'll stop and say thank you and look forward very much to the conversation.
감사합니다. 링컨 데이비스 교수님. 오늘 연구를 하는 데 있어서 비교법 연구를 하는 데 있어서 6가지 함정과 7가지 유용한 정보, 그리고 3가지 전략을 아주 굉장히 잘 정리를 해서 말씀해 주셨어요. 이거는 저희 지금 시청하고 계시는 그 케일로 포럼 참여자들 뿐만이 아니라 이제 저희 내부적으로도 연구원 내에서도 모두에게 공유하고 연구를 하는 데 있어서 활용할 수 있도록 해야 되겠다 생각이 듭니다. 그리고 말씀하신 중에 또 한 번 그 자료의 얘기가 나왔습니다. 아무래도 외국의 학문을 연구하는 데 있어서는 1차 자료나 2차 자료가 굉장히 중요하기 마련인데, 어제도 나온 이야기고 오늘도 이제 다시 한번 나오고 있지만, 한국법의 자료는 이제 저희가 한국법제연구원의 책임이 막중하다고 생각이 들고요. 저희가 법제연구원에 이제 번역 센터를 가지고 센터에서 한국법을 계속 영문으로 번역을 하고 있는데요. 그것과 같이 또 저희 그 교류 지원 사업에서 케일로 포럼을 운영하면서 작년부터 케일로 아카데미를 또 런칭을 해서 해외에 있는 한국법을 공부하고자 하는 분들께 한국법을 강의를 할 수 있도록 교재를 계속 발간을 하고 있습니다. 그 부분도 공유를 해드리고 더욱더 활용을 할 수 있도록 말씀드리도록 하겠습니다. 그리고 막간을 빌어서 잠깐 광고 말씀을 드리자면, 번역 말씀을 해주셔서 저희 번역센터에서 또 번역을 주제로 올해 그 국제 통번역 포럼을 다음 주에 7월 15일 날 또 온라인으로 개최를 하게 됩니다. 혹시 관심 있으신 분들은 사전 등록하시고 많은 참여를 부탁드리겠습니다. 오늘 이렇게 세 분의 굉장히 다른 발표를 해주셨는데, 이 세 분이 발표를 모두 한꺼번에 이제 원재천 교수님께서 어깨가 무거우신데요. 원재천 교수님께서 토론 말씀을 해주시겠습니다. 원 교수님 부탁드립니다.
Well, thank you, Dr. Che, and thank you also for the Professor Robert Lee and Professor No Jong-ho, and also Dean Lincoln Davis for really your engaging presentation. I think this is like Dr. Che said, you all have 3 different topics. Dean Davis talked about research, international comparative research. You kind of mentioned the qualitative research in a way, and also talked about data. So you're talking about the quantitative research. So I could see that now how our law research is becoming much more like social science oriented. I appreciate for your sharing. As to the Professor Robert Lee, and you have very distinctive experience of teaching American law to Korean audience. International audience, I guess, and and also you kind of brought, you talked about you did your extensive research on chaebol, but probably in a broader context, there's like corporate governance, and especially now with all the changing of law, labor law, tax law, inheritance law, Korea is going through really fascinating time. And also, Professor No Jung-ho, I know that you are expert in like corporate law and also different dynamics of economic law and big picture. But thanks for you sharing particular insight on North Korean human rights law and within context of the U.S. Human rights law, and especially there was a very a big debate within Korea as to Anti-Leaflet Law, that there are literally a group of people felt that you need to really regulate particular behavior when it's threatening our quote-unquote national security. But you did mention that the leaflet North Koreans had a right to information, and also South Korea Human Rights Commission actually made a position that the leaflet is right. South Koreans do need to help North Korea with all forms of aid, human rights aid, but especially area of the information. So that's really interesting ongoing debate we are having in Korea right now. This is what I'm going to do. I will ask a specific question to each of the presenter, and then after that, I will give you all a kind of common question. And common question will be much broader than like Korea, because as you know, Korea and North Korea, we mentioned on North Korea today, and then mentioned human right, but when we say human right is much more than civil and political right, energy right to information, technology, all those ongoing things we need to resolve and address even during the process and after unification, and also within context of the East Asia, China, Japan, and Korea. So this is eventually how I would like to give a discussion and like to really hear your really insight on these matters. Let me first pose a question to Professor Robert Lee. You did mention about your research on Korean like big ownership of the big companies, and I'm just curious as to, with all like technology investment, some people, Korea is now like top 10 economic nation, and I think that now we quote unquote no longer a developing country anymore. I don't know who ruled it, but so a lot of people feel very glad, especially young people. Probably that's with the K-pop and everything, that's how they were feeling. But especially older folks, the people above 40, we have this like, we had all this like special favor as to a developing nation in trade, FTA, and all that. So, but at the same time, you also know that like in big technology or microchips and all that, it takes a lot of resources to invest and to lead a particular industry. So is it fair that the talk about ownership of the particular family is whether relevant in Korea or not? My question is really that in the United States, I'm not an expert in U.S. Business law or for that matter corporate governance in U.S. corporation, but is it fair that you compare like Samsung with General Motors or the Ford? But is it like one of the advanced industry of the United States, a financial industry? Is it really who owns the financial industry? Or does it, so is any particular industry or practice that you feel that you can compare the US particular practice with the Korean business practice? And then, and one more, I guess, the issue of concern is that there is a lot of discussion as to the government regulation in Korea. That is one thing that, of course, you talked about a ownership of a particular family with a particular big corporation. That's one thing. But within Korea, there's a lot of discussion as the labor right. In Korea, that labor party has a very dominant influence in society, and the regulation, Fair Trade Commission's investigation, prosecutor's office now they just added a mandate on financial investigation and all that. So if you could kind of share your experience in Korea, that there's certain people said we are becoming more welfare kind of more European, socialistic rule of law country, but some other people say that basically our strength is a free market economy, and then often you kind of lead a trailblazers and all that. If you could comment on that, this would be a great time for me to learn. Thank you, sir.
Thank you for the question. I'll just share some thoughts that I had in terms of comparisons between the United States and Korea. One of the thoughts that I had thought about, but did not really, to be honest, have time to fully develop, to investigate, and to analyze, is from the perspective of business organizations. So we talked about, for example, how in the previous inquiry, the examination of the Korean corporate system, and perhaps an analogy or comparisons between companies, big companies like Samsung and Apple, and what might account for the differences are appropriate. And so that was a prior inquiry. But one of the things that I had a question about, but never really had the time to fully investigate, but I think it's one that is worth investigating fully, is that you mentioned that Korea has left that label, and I think a while ago. It's a fully developed, advanced economy, and on par with all of the other fully developed economies in the world. And so one of the questions that I had as I departed and left on that final trip to come back here was, in Korea, the dominant business organizational form is the corporation, is the 주식회사. And in looking at the Korean Commercial Code, that as an outsider, particularly one that is studied under the U.S. system, it does look quite regulatory. That there are quite a lot of mandates, and that's one of the first things that I picked up on. In the U.S., corporation law is considered essentially an enabling law, where contract is the dominant analogy, contract is the dominant framework. And in the Korean system is different in a number of ways. The U.S. has undergone some developments in the past several decades, and whereas prior to, I would say, the 1990s, you can look at the forms of business organizations in the United States as broadly one in the realm of, say, partnerships, and then corporations on the other side. Now we have evolved into one where I believe it is one of corporations, and particularly with a focus on the publicly traded corporations on the one hand, and non-corporate business entities, and particularly the rise of limited liability companies. So in Korea, I was looking at the partnership statutes, and there is also a statute or statutory section that deals with something called limited liability companies, but I saw that it was not quite as developed in terms of the business organizational form. So a question, I don't have answers, I just have questions. One question is whether or not as a developed, advanced economy, does Korea need another business organizational form in the way that the United States has learned in the past several decades, particularly after certain tax rulings came out in the late 1990s that were favorable to an alternative to the corporation as a business form. So in Korea, I would imagine that one of the things that the country will want to explore or will want to develop is there are these enormous big corporate enterprises, the Jebels, the corporate conglomerates that everyone is familiar with. But in what way might the Korean economy, might the country also want to develop homegrown entrepreneurial ventures that not only are basically simple in form, like storefront businesses, but have the capability to develop into something that's more. And the question that I have, given that as a policy end, and it's something that is desirable, I would think, given that desired goal, is there something that perhaps business organizations, the laws of business organizations, might do to facilitate that kind of an aspiration? And so, as I said, in the U.S., now it's pretty clear that there are two worlds in the world of business organization. One dominated by corporations in which public corporations, and there's several thousand here in the U.S. That's a small number, actually. You know, it used to be much larger number of public corporations in the United States. But when we talk about corporations, you know, the most important kind here in the U.S. are the public corporations. So that's one world. The other world is non-corporate business entities, of which limited liability companies are the fastest growing business entities in the U.S. in terms of the number of filings. And what I can say about the LLCs is that they are no longer just simply storefront kind of businesses, you know, mom and pop restaurant, come here, eat, but in fact, large enterprises are also using this form as well. So it's more of just simply a question that I have. If I had another year in Korea, and I don't, but if I had one, that would be the inquiry that I would actually pursue in Korea. Does Korea need another business entity form? One that is more contract-based, one that is fewer and that is lesser in terms of a regulatory tint that we see in the Korean commercial code with respect to 주식회사.
Yeah, well, thank you, Professor Lee. It is very insightful that you use the word that how U.S. corporate law is more like enabling law, whereas the Korean corporate law is more like regulatory law. Do you perhaps feel that this is because we have like a little different legal tradition or roots, like U.S. is based on common law and Korea is largely based on continental law, Professor Lee?
Yes, thank you for that question. So my view is that it is, in fact, partly due to different traditions. One of civil law versus common law, but I think that there are also other aspects to it. So, for example, the notion of the corporation as a form of a contract goes back hundreds of years, in fact, to the original Dartmouth case back in the 18th century. But in the United States, the tradition, certainly in the modern corporate law, and when I say modern, I'm talking about at the turn of the 20th century, that it has become more enabling. Now there's a range of enabling and the contract analogy. So in the U.S., LLCs are really truly a form of a contract, whereas in the whole range of business entities that we see, the corporation is actually more regulatory here in the U.S. when you just look at all the different kinds of U.S. entities, partnerships, limited liability companies, and corporations. But I also think it is related to the different historical origins and different cultural traditions in the two societies, and particularly the historical origins being that that Korea was a development economy, that the state plays a much more of a direct role in terms of directing the economy. You can see some of these aspects in the Korean Constitution itself, where the government plays a role in the economic welfare and the well-being of the Korean citizens. So going back to the original modern Korea Inc. or the Korean economy dating back to the 60s and 70s, and also I believe different conceptions of the corporation and what the ultimate purpose of the corporation is, might be very different from the way that Korean policymakers, the Korean government, the Korean elites, and the average Korean citizen in the streets think of what the function and the purpose of these corporate enterprises are, compared to the United States, and particularly the United States post 1980, where we've had much of these debates, robust debates about the role of the corporation from 1980s onwards. These kinds of discussions were always there in the United States. You can kind of go all the way back to even 1919 in the Dodge versus Ford case, and then the 1930s with the Dodd-Meade debates. So these kinds of discussions were always there. But they took on an urgency and a primacy, probably dating back to the early 1980s, where now we are at the point in the United States where the notion of shareholder primacy is very firmly entrenched in U.S. corporate governance, I think U.S. corporation law. So a number of different factors, I think, come to bear in terms of why Korean corporate law is much more regulatory in form than we see here in the United States.
Thank you, Professor Robert Lee. I will ask a question to Professor Jung-Ho Lo. You actually have a very interesting and distinctive experience as you practice law in United States and Korea. You worked in Korean government, and also you teach Korean law and in New York, Columbia. But more fascinating part of your career is that you actually negotiated with North Koreans and their legal authorities and their decision makers, and particularly you were a advisor to Korean government, KEDO, the North Korean Light Water Research Project. I'm really fascinated about that because I do see that, of course, human rights is, there's a human right for children, disability, that's all important, but really without energy, you cannot have a clean water, you cannot really have a hospital, and without energy, what can you produce? So, Professor Law, if I may ask you that, what was your experience negotiating with the North Koreans? You actually went to North Korea a couple of times, and what is North Koreans' law and legal culture? I know that they have a constitution and the regulation, but don't they also have like some kind of their own version of Ten Commandments? And what is the weight of their supreme leader? I mean, does it really important in North Korea? Then within that, how do we, if you can kind of give us a little background about North Korean law and legal culture, and second, if you had to continue KEDO 2, how would you structure and strategize the negotiation, energy, and all those cooperation with North Korea? Professor No.
Well, Professor Wang, thank you. I think your question has basically covered about 8 weeks of my course at Columbia Law School. I'm not sure whether I can actually sufficiently answer all of those questions, but I do thank you for that question. And I will try to, if I can remember all the questions that you raised, try to address some of them. My involvement with the Korean government as a legal advisor to the light water reactor program, it's called the light water reactor program, dates back to the agreed framework between the United States and North Korea upon the death of Kim Il-sung, whereby it's essentially a deal was made to freeze the North Korean nuclear program. And in return, North Korea would receive 2 light water reactors. They're nuclear reactors capable of producing energy to North Korea. And essentially, it's a quid pro quo for North Korea coming back into compliance with international safeguards and inspections that, in fact, the United States, through a consortium of formed by Korea, Japan, United States, and the EU, that would provide this energy source. So with that, essentially my role there was, once the project began, was to negotiate a set of protocols with North Korea to enable now this project to go forward. And here, this was a very interesting time in my life. This is many, many years ago when I was much younger. That in fact, it was an opportunity to engage with the North Koreans directly on a matter of law, understanding or educating North Korea regarding what a international legal obligation is all about. And one of the first tasks that, we did was in fact to bring North Korean policymakers, lawyers, to third countries, and in fact, begin a process of sharing information regarding how a legal system works and what your role or the role of a particular nation in a rule-based society would be. So that would include many things like basic tort law, basic contract law, and of course nuclear liability law. And through this process, I think it was a tremendously important way to engage North Korea out of their kind of hermit kingdom kind of mentality, and give them a first-hand opportunity to understand how these kind of legal systems, how they work with each other. And here, if I could just share with you some of the, I'm sure I can't share with you all of the events that occur, but there were very interesting moments, and I was very optimistic during the time that I worked at Cato that, in fact, given the right set of motivations and international kind of inducements, in fact, North Korea can be a part of this international community. But of course, as you all know, that deal really did not happen. One of the reasons, also, without going into the academic part, was just that the power grid system in North Korea was so poor that, in fact, I think even having a nuclear reactor in Sinpo, that's in the eastern coast of North Korea, having these 2 huge nuclear reactors, you simply could not even get the electricity to the rest of the country because the power grid was so poor. And actually updating the power grid to enable a transmission of electricity through the nuclear reactors, that would actually have cost about as much as providing the nuclear reactors. So, that project was kind of challenged from day one. In terms of the actual negotiations, here Well, one of the things I mentioned in my presentation was the notion of domestic law as an important part of complying with international obligations. And North Korea, I think this was almost their very first experience at saying, when you enter into an international obligation or international treaty, then there must be a corresponding enabling law domestically to ensure that this happens. An example, in a nuclear world, essentially what happens is once a nuclear power plant is built by foreign members or otherwise, the actual obligation or the actual responsibility of nuclear reactors lies with what we call the operator, and the operator is North Korea. And the reason why they have structured this in this way is that they want to ensure that should there be a catastrophic accident or some sort of a failure, where there is trans-border radiation leak or some injury to South Korea, Japan, China, or otherwise, that in fact North Korea would remain liable for the indemnification and the kind of the legal responsibilities stemming from operation of the nuclear facility. And this is where we actually had much of the problems of attempting to kind of persuade North Korea that in fact this is a bona fide obligation that you must undertake if you are, if you are to now go on with this project and have nuclear reactors. And much of the negotiation really focused on kind of convincing North Korea or negotiating with North Korea that these were not onerous obligations that we were kind of putting on you, but a part of a international legal system that if you want certain benefits of nuclear energy, that you must comply with certain rules on safeguards, inspections, liability, and whatnot. And here we never really actually had a chance to finish these negotiations because the actual Keto project, the under the agreed framework, was stopped midway. But nonetheless, it gave me kind of a glimpse into the future, whereby North Korea is not just some crazy country, but in fact, it is possible. And through the Keto project that we embarked on and started, that in fact, whether it be nuclear liability, tort law, or otherwise, that clearly there is a capacity for North Korea to be a part of this community. And my presentation on human rights really was on that particular point, that in fact, when it comes to international obligations, the covenant on political and cultural rights, or on rights of the women, or whatever it is that's international, at a certain point in time, I think North Korea really has to recognize that they can't really go at it alone, but in fact, it is all intertwined community and based on a rule of law, governed by law, and in a way, that project in itself was the first foray, of North Korea into that particular kind of necessity of, complying with international obligations, and hence, to me, I think that was really the value of engaging with North Korea. And with respect to kind of other things, I think Professor Wong may have to have a couple of drinks, and I can share with you some other more interesting details. But let me end it there for the moment. I don't know if I answered all of your questions. I'm sure I didn't, but I did my best shot to.
Well, thank you. Because as far as I can see, that the nuclear is such an important issue that even Biden administration eventually they will have to talk to all the concerned parties, and then security, and then even we will have to talk about a cooperation. Then energy cooperation is inevitable. Let me just ask the quick last question, then I will ask the discussing question to Dean Davis. And Professor know that if you had to apparently now, okay, when you talk to the North Koreans at the beginning, it was fascinating that you brought them to the like third country, and they kind of really share the international norm, liability, and all this in boundary liabilities. If anything happened to North Korea, probably will impact China, Korea, Japan as well. And then, so that was like some years ago. Do you think that North Korea's legal culture has somewhat more became international now that they are party to more international human rights committees? Or what should we expect when we begin the second phase or next round of the negotiation with North Koreans, sir?
Yeah, that's an excellent question, and one that I would only be speculating on because of the kind of lack of information regarding what North Korea does internally. But if I may just have a quick speculation, what's become quite clear is that there is, I think, a recognition by North Korea through, if you look at their laws, which are available in the West, that in fact they are becoming more attuned to what the requirements of the international community are. And the four examples that I gave, the protection of women, elderly, children, and the disabled, irrespective of what you feel about the actual enforcement of that law or the practical enforcement, the fact of the matter is that it is on the legal books, and that in itself, I think, in my mind, points to that North Korea is going at least in the right direction. Now, whether that's sufficient or not, I'm not going to give an opinion on, but clearly that is a major kind of change that has occurred that is very different than when we first began this process in the early 2000s. So it's almost 15, 20 years ago that we had done. And at the time, when we first began this project, the kind of notion of contractual obligations, the notion of tort or state liability or responsibility, all of those were rather, not, I wouldn't say foreign, but not up to the kind of standards that we would expect for a country that ultimately would be part of a nuclear power nation. And hence, since that time, I'm speculating again, but I think clearly there has been incremental, I think, developments in the right direction. But again, the sufficiency of that is something that we just have very little information about how it works in North Korea. So, so let me leave it at that.
Yeah, thank you, sir. Dean Davis, you did a lot of research in like energy, nuclear, renewable energy, and especially international research. Now that, let me actually build on what the Professor No shared. Now that if you are to, since I would love to have you in my academic PhD course as a special lecture, and then you give us the international comparative legal research. That's because we do have a methodology class at our university, but it's always it's so good that what you shared today. If it's okay, I will share your slide with our students on that. But beside that, if you are to now implement your theory, let's say, and also if you are, it appears that if, like what Professor No said, if anything happened to, let's say, a North Korean nuclear reactor, for that matter, South Korea and China, then all countries will suffer together. And recently there is a big issue as to Fukushima, the nuclear reactors. They will about to release quote unquote treated water, which, and for whatever reason, IAEA thought that that's technically okay. But imagine the Korean fishery and not only Korean fishery, but Japanese fishery. I'm not sure that how they're going to be compensated. And so this is not only North Korea's future issue, but with the, of course, right now, South Korea is like going full renewable energy with like wind and solar energy and all that. But China is actually the one of the main nuclear reactor nations. So the first question, do you see a kind of regional nuclear regulatory protection, even compensatory, like a regime covering the East Asia? And then two, if you think that that's necessary, how would you conduct a research like what you shared involving local experts, authorities, and so they have some kind of and present a need, and what are the some basic structures would you implement to have a kind of feasibility research for maybe requesting whether there's such a regime, and at some point, how would you incorporate research North Korea into your research? Sure.
Yeah, no, great questions. And I think, with respect to nuclear, it's, nuclear is one of the most difficult questions in terms of energy. And I think, it's difficult in part because of kind of the psychological fear around it, the notion of sort of radiation and, risks that we can't really envision and we can't really wrap our heads around how to calculate the sort of infinitesimal nature of the risk. But then the fact that when you do have some kind of problem with nuclear power, you're going to have, really cataclysmic impacts. And, the truth, of course, about nuclear is that in terms of the terawatt hours produced of energy or electricity, it's the safest technology around. But it does have this history of, three sort of key accidents. You think about 3 Mile Island, which was quite minor, Chernobyl, which was obviously devastating, and then Fukushima, which, was obviously sort of part of a triple catastrophe in Japan in terms of the earthquake and the tsunami, and then the nuclear disaster as well. And so, you look at it, and I think people sort of shirk at the question initially. And then the other thing that happens with nuclear is they kind of collapse all of the questions about nuclear power into one or two issues, when really it's sort of a much richer and much more complicated question, right? If you think about nuclear, for instance, just from the perspective of climate change, there are trade-offs we're talking about in terms of the cleanness of the power, the reduction of emissions, and what that might look like compared to other resources. But then you're sort of weighing the risk of an accident. But if you really break that question down, there's really sort of three parts of the question. One part is, what do we do with existing reactors that are already functioning and providing climate benefits already? A second question that you might assess is, what about constructing new reactors? And of course, as you mentioned, China is really leading the globe on that front right now. And then the third question is, well, what about new technologies? Small modular nuclear reactors are being explored, advanced reactors are being explored. Is that a way forward in terms of how you manage nuclear? So, really complex questions just around the technology itself. In terms of a compensation regime, I think certainly as you look at, one country like Japan really impacting other countries around it, Korea, China, et cetera, that would seem like an area that would be ripe for a kind of regional solution to how you deal with compensation, especially as you worry about commercial enterprises that are essential to living, like fisheries. And so, how do you move forward with that? I think, on the one hand, there's sort of the political question and the political wherewithal to get to an international arrangement that might be trilateral or more. I think that's above my pay grade in terms of whether you can get the politicians on the same page. But there is a really fascinating legal and policy question that you've raised in terms of how do you design that kind of arrangement. And I think what I would say is, in terms of conducting that research or maybe helping write the legislation, thinking through what it would look like, the first step I would probably take is to try to think about parallel regimes that might exist, maybe in other parts of the world or other areas of the law that aren't necessarily energy, and to think about what some of those different mechanisms are. So the first step might just be a cataloging, creating the sort of list of what's there in terms of what tools do we know that are already in the tool chest. The second step might be then trying to match that up against the type of problem that you have. And again, not just thinking from an energy context, but from other environmental contexts or other dispute resolution contexts, other economic harm types of contexts, because I think you are going to have other areas. And so you might want to cast a pretty wide net in terms of the type of experts you're talking to. And I think once you've done that analysis, then you can start pulling together the lessons. But I think, one of the things that's always true in the law, I used to work with an attorney named Chuck Cole, who's just this brilliant appellate litigator. And he always said, you've got to go to the scene of the accident or the crime. And I think that would be true here too, finding the right people in each country to talk to about who's being impacted, how they're being impacted, and really hearing that on a sort of first person perspective.
Thank you, Dean Davis. Let me, next, really, the remaining of time, I think this is a really rare opportunity that we have a professors that who is teaching like Korean law, introducing Asian legal system in the United States. But also we have two professors that actually all of you who had experience teaching in Korea. So let me ask some general question to all three of you, and you can really share. One, when like a Professor Lee and Professor Davids, when you were like working and teaching in Korea, I'm sure you had much interaction with the Korean lawyers, law professors, and kind of look into the Korean legal culture. And there's interesting discussion within Korea, for that matter, like kind of Asia tradition, that 법치 and 인치. So 법치 is like, as far as I know, rule of law or rule by law, and inchi is like rule of law but ruled by human. So basically, you want a very benevolent ruler or decision maker, and who would kindly, like a big father figure, like a big government and all that. So let me first ask the question to Professor Lee, and for that matter, I think that Professor Roh, you actually did your undergraduate work in South Korea. So actually, you have kind of more inside person's. You could have an inside person's perspective. Let me first begin with Professor Lee. That do you think that of looking into Korean legal historical background, we have kind of Western corporate law, I guess, but the way we run our law is more like Asian, or is more like a person. Government is still important. White House or our version of Blue House, they make a decision. That thing, that becomes the modern law. Actually, that's becoming a de facto law in Korea. Is that your experience, like inchi, 법치? Can you kind of comment on that? And then if you also compare that with the United States. And I want to ask the same question to Professor Dean Davis. You not only worked in Seoul National University, but you are in my town, very close by our provincial capital, Daegu, with the local scholars, local environment. And go ahead, Professor Lee.
Thank you for that question. I suppose when you were making that distinction, the first thing that popped into my head was my colleague at Yonsei, Kim Jung-gi, who in his prior writings, he talked about how there is a rule of law, the concept of a rule of law, and made the observation that sometimes in Korea, it's not necessarily the rule of law, but it's the rule of man, meaning driven by personality, driven by specific individuals, and so I think that's an apt observation. And with respect to the governance, corporate governance specifically, I think that's an apt observation as well, particularly with the role of the families and the role of the government in Korean corporate governance. So what I would say about that is, again, just in terms of my own years spent studying as a student of Korean law and Korean legal issues, particularly with respect to corporations, is that that seems to be the case. And there might be, as I say in my article, there might be, although there are flaws to that kind of a system, that these flaws are not irrational or illegitimate, that there might be rational basis for why Korea has developed maybe a tract of not only just the rule of law, but the rule of man, as my colleague at Yonsei has stated in his prior writings. Looking into the future, how might that, what do I think about that? Well, I suppose that kind of, in light of the fact that that I do think that the Jebel system, for all of its flaws, for all of its problems and its inefficiencies, that there's a rational founding for why it is that that system exists and continues to exist. And in light of particular social and political issues, I think that that distinction will probably still hold in Korea. And in terms of my earlier comments about, well, what about going past the big, large corporations, the green shoots of entrepreneurial ventures? I think in that area, I think perhaps maybe the rule of law might be a more probably more apt framework to think about contracting, think about whether or not contracting among venturers with less of a footprint, less of a public footprint, at least as ventures go, might be a good route. So thank you for that question.
Thank you, Professor Lee. Dean Davis, a similar question, but I think that I want you to take that. Is Korean law and legal culture any different from Japanese law and legal culture, and for that matter, Chinese law and legal culture? If you could make some general observation.
And
Yeah, so I mean, I think
if I may
it was
interrupt,
interesting when you asked the initial question about sort of U.S. versus Korea, because I heard you describing Korea, but I was thinking that sounds just like the
excuse me,
U.S.
Dean
to me.
Davis. Excuse me,
Yeah.
Dean Davis. I'm sorry to interrupt, but for the sake of time management, if you can make your comments in 3 minutes or so, that would be perfect.
No problem.
Thank you.
Yep. So, what I heard you describing is sort of Korea sounds a lot to me like the U.S., right? You look at, sort of the U.S. Supreme Court cases, and you sometimes wonder, is it rule of law, or is it sort of the particular justices that are on the court at a given time? I'm thinking about a case recently decided by the Supreme Court on nuclear power and preemption under the Supremacy Clause felt to me a lot like not really addressing the key question, which was, do we like this old precedent or not? And so we're going to, sort of fracture in how we come out. And so, and maybe that's less so as you get down to the appellate courts and the district courts, and it becomes a little bit less political. And, sort of how you measure that's a little bit tougher. I think you have to really sort of be immersed in the context. In terms of, Korea versus Japan or China, I've not been to China. I've just read about some of their laws and their interactions. I think very different from Korea, China versus Korea, from every sense I've been able to get, very much in terms of the communist history and sort of moving to capitalism, but still having a really centralized governmental function that's quite opaque in contrast to Korea, which is much more transparent and I think much more akin to the US or Europe in that context. And my sense is Japan, quite different from Korea also in terms of just sort of some of the opaqueness and obviously very cultural, strong cultural differences between Korea and Japan. From the interactions I've had in both countries and giving some lectures in Japan as well. So I would say very much some differences.
Thank you, Dean Davis. And my last question will be a quick question to Professor No, that you can talk about 법진지, but I guess my last question to you is that have you thought about maybe bringing like North Korean scholars and lawyers to Columbia and then have some kind of program like you had before? And then just curious, and then I will end my discussion here. Go ahead, Professor No.
Sure. That's something that in New York we obviously pursue through the United Nations. And in fact, last year, 2 years ago, we did have a delegation of North Korean government officials through the United Nations come, and I hosted an event at Columbia for them. But of course, all of that is under strict sanctions and under the control of the U.S. government. But if I may just use this forum just to make a brief statement, this is that in fact, even though North Korea is the enemy, is the foe, of the United States, engagement is a very important part of how we get to understand the adversaries, why they're behaving the way they do, and this kind of outreach, I think, even in a neutral third forum like a university or a law school, I would hope we can continue to provide some of that kind of understanding and cultural exchange, legal understanding through these kind of meetings. So yes, to answer your question, I will continue to pursue under the system of what's allowable under U.S. law and the United Nations.
Thank you, and thank you for great discussion. And I'd like to invite all of you, including our participant, to come to Pohang, and we can do serious water law raw fish together. Okay, thank you. Now back to you, Dr. Che.
발표 시간을 조금씩 발표자들께서 좀 줄여주셔서 시간이 남으려나 했었는데 굉장히 이 세 분의 열띤 토론과 깊이 있는 질문과 통찰력 있는 답변으로 이렇게 시간이 금방 갔습니다. 지금은 굉장히 시간이 촉박한 상황이긴 한데 또 여러분들이 질문을 보내주시고 계세요. 그런데 지금 또 다음 세션을 진행을 해야 되고 제가 여기서 타임키퍼의 역할을 해야 되기 때문에 일단 마지막으로 저희 원장님 질문 하나만 받고 그리고 마무리하도록 하겠습니다. 원장님.
네, 감사합니다. 노정호 교수님한테 질문을 좀 드리고자 합니다. 북한 주민들이 국제법이나 북한법에 따라서도 인권이 주체가 되고 그러한 사실은 다양한 방법으로 잘 알려야 된다라고 하는 그 가치에 대해서는 얼마든지 다 동의를 합니다. 대북 전단법 문제를 제가 말씀드리고자 하는데요. 대북 전단법은 그러한 그 북한 주민의 인권의 가치를 다양한 방법으로 알려야 된다고 하는 그러한 가치와 그런데 전단이 뿌려지는 장소 자체가 접경 지역이고 접경 지역에 거주하는 주민들이 대한민국에 112만 명이라고 그렇게 지금 전해지고 있습니다. 그런데 그 주민들의 생명 안전에 굉장히 위협적인 상태를 초래하기 때문에 대북 전단을 뿌리는 방법에 의한 인권을 알리는 것은 적절한 방법이 아니다라는 것이 대한민국 국회와 정부의 판단이고 그게 입법화된 것인데 그 입법이 미국에서의 북한 인권법과 충돌하는 문제가 있다. 양쪽에 다 형사처벌되는 문제가 있는데 이러한 문제를 한국법의 특성이라는 측면에서 이해할 수는 없겠는지, 그리고 그렇게 지금 현재적으로 지금 문제되는 상황 어떻게 해결되는 게 맞는 건지 그 부분에 대해서 노 교수님의 의견을 좀 듣고 싶습니다.
Okay, I think that was translated. Thank you so much. That is the precise reason why the anti-leaflet law is so controversial, because it goes directly to a national security issue versus a freedom of expression, freedom of speech issue. One of the biggest problems of the anti-leaflet law, and I don't dismiss the importance of protecting those people who are in the northern areas, but is the overbreadth, how broadly it applies. And what I mean by that is not only does it apply to South Koreans in South Korea, but also there's a phrase, third countries. So if it goes to a third country, that in itself, through a third country, is also punishable by law. And that's really a very overly broad way of preventing any kind of information from going into North Korea. So without really going into the details of politics regarding why the anti-leaflet law was made in the first place, in a way as a result, direct result of certain words that were relayed by the North Korean leadership regarding the leaflets. Aside from that particular part, the law in itself is kind of troubling in a sense is that it does restrict the kind of free flow of information that is integral to now kind of bringing in information to North Korea. And under the U.S. law also, in fact, the method by which now most of this occurs through South Korea or sometimes through China, but by cutting off that avenue, more than anything else, I think it sends a very chilling message regarding how committed South Korea is towards kind of the North Korean human rights, and that's really one of the kind of major reasons that many of people in the United States and outside of Korea really question why such a law is really necessary at this particular point.
네, 감사합니다. 답변이 되셨을 것 같습니다. 네, 저희 시간 관계상 더 질문과 답변을 이어 나갈 수 있으면 매우 좋겠습니다만 시간 관계상 지금 세션은 이번으로 마무리를 해야 될 것 같습니다. 아까 링컨 데이비스 교수님께서 이제 연구를 하는 자의 중요한 전략 중 하나로 네트워크 말씀해 주셨는데 정말 이런 기회를 통해서 이렇게 알게 된 이런 여러 연구자들을 계속해서 다음 기회에 또 모시고 더 좋은 말씀을 더 들었으면 좋겠다는 생각이 듭니다. 문재천 교수님 말씀하셨던 것처럼 다 같이 포항에 가서 물회라도 먹었으면 좋겠고요. 다음번에도 저희 KLO 포럼에 또 모시고 계속해서 진지한 논의를 이어갈 수 있었으면 좋겠습니다. 이것으로 세션 2는 마치고요. 유튜브 생중계는 여기서 이제 중단이 됩니다. 그리고 세션 3가 10시 반에 시작이 되니까 그때 다시 유튜브로 들어와 주시면 감사하겠습니다. 그리고 참석자 여러분들께서는 지금 이렇게 온라인으로 다 같이 그룹 포토를 찍도록 하겠습니다. 랩탑 컴퓨터에 그 카메라를 이렇게 봐주시고 Let us take a group photo in my count 1, 2, 3. Smile and let me take another shot to make sure that I got everyone smiling. So 1, 2, 3. Okay. Perfect. Thank you. 감사합니다. Let us take a group photo in my count 1, 2, 3. Smile and let me take another shot to make sure that I got everyone smiling. So 1, 2, 3. Okay. Perfect. Thank you. 감사합니다.